Today we are going to talk about how patent pending status can be extremely valuable. And Tom has a really great story about this that you gave me the quick version of it a little while ago, and I'm excited to hear the longer version of it.
Okay, so the quick version was like 45 seconds.
Right.
The long version will be like 5 or 10 minutes.
Okay, perfect.
So let's do that.
Yeah.
Okay, so first of all, patent pending. That's what we're talking about. So you get a patent, right? And you have the power to prevent others from making, using, selling, or offering to sell your patented technology if you have a patent. The problem is it takes like 3 years before you get a final determination on whether your invention that you've applied for patent protection for will be actually patentable and become an issued patent, right? So what happens during all that 3 years? Is there any value that you can get? And you can. There's something called patent pending. And there's a few kind of like direct value points that you get. One is you can mark your products with patent pending. You can mark your services if they're patented, or if you filed a patent application with patent pending. In fact, this is such a powerful deterrent to people when you mark your products with patent pending that there's actually a law against false patent marking. You actually are not allowed to mark a product or service with patented or patent pending because it's such a big deterrent. Because if I see a really cool product in the marketplace and I'm like turning it around and stuff to see if it's patented and I can't find any mention of it, and then I go do a search and I can't find anything patentable about it, I could technically make a mold, start making it, copy it exactly as it is, and start selling it in the marketplace and competing with whoever was making that first product, right? Mm-hmm. Because remember, a patent doesn't give you the right to do anything. It gives you the right to prevent other people from doing something, right? So if there's no patents, you can make, use, sell, offer to sell any products you want. But when a patent pops up, that's when you have to start to watch yourself because you can be prevented. So if you pick up that product and you see patent pending on it, you're going to go, wow, patent pending. That means they're probably going to get a patent on it any day now, any week, any month now. I'm not going to tool up and get myself all excited and gung-ho and spend a fortune to start making this and selling it in the marketplace if a patent's going to pop up in a few months or even a year and block me. So it's a really powerful status. So the story I was telling you today is that patent pending can also help you to get third-party investments. And here's what I mean. So back in 2000 or so, like 25 minutes before the dot-com crash, I had a business plan that I was seeking an investment for. So my business idea was to create an online marketplace for something called defensive publishing. And defensive publishing is essentially a way to publish innovation so that nobody can get a patent because it becomes prior art and it blocks patenting. So anyway, we had an idea to build a site where we would, use, I guess it would be kind of like an early stage of blockchain to prove that this publication occurred on a particular date and time and was never altered so that people could use it as prior art. So instead of patenting, you might just publish with us. And that was our idea. But all we had was a business plan. We didn't have a product. We weren't in the marketplace or anything. So Ray, you're too young to remember this, but for those of you for those in the pool of millions who are watching our podcast who might be old enough, you might remember that before 2000, people were getting investments based upon business plans, no products. It was kind of a running joke that if you put .com after anything, you could get investment money. So anyway, in like 2000, again, just before the crash, I went to a VC to get an investment for this new defensive publishing business. And my pitch to the VC was, I will give you 20% of the business for a $7 million investment, which would have given us a post-money valuation of $35 million, right? So I pitched the idea. They loved the idea. They didn't particularly like me because they said that I had no experience. I was just a lawyer. And they didn't like the fact that we were in Buffalo, New York, because they said all the cool companies are in like San Francisco, Silicon Valley area, Austin, Texas, maybe Boston, but certainly not Buffalo. But they love the idea, right? So they said, we really like your idea. and we're going to use your idea, but we don't need you because we'll put our own CEO in place and we'll do it in Boston or Austin or Silicon Valley, and we'll make a killing because we really like your idea. Because the reason they liked it so much is back in those days, every business model on the web for the most part was money for clicks. It was all about monetizing eyeballs, right? There were no real models where people were selling stuff, or there were, don't get me wrong, there were models, but most were all about eyeballs and monetizing those eyeballs. So we had an actual annuity business on the web where people would publish with us, we would date stamp it, and then they could continue to pay us annuity every year or 2 years or 3 years. So they really liked it. So the problem was me, the problem was Buffalo. And the problem was we had no market traction. We had no product. All we had was a business plan, which they could easily replicate because I just gave it to them, right, in my pitch. So anyway, I should have had them sign an NDA, but that's probably a discussion for another day because they wouldn't sign an NDA because we were this big and they were bigger than I could spread my hands on the screen. So anyway, we went.
That is a topic for another day.
That's a topic for another day, exactly. So anyway, we went. I had a partner on this with me. We went to the meeting. They rejected us, but they said they might do it anyway. And they basically shuffled us out of the office. I mean, they didn't use security where, the shows where you grab them by the back of the collar and the back of the pants and you throw them out. Yeah. They didn't actually, and then they're tumbling outside. They didn't actually do that, but it was close. So anyway, we went back. Right. We went back and filed 7 patent applications the next week. So we now have 7 patent applications filed. We've blocked the whole space, right?
Yeah.
So we went for a follow-up meeting with them and we showed them our 7 patent applications, and it was a very different meeting. Within no time at all, 90 days from that next meeting, they invested $7 million for 20% of a business that had nothing more than a business plan, no product. Mostly because of the patent applications. I say mostly because they really liked the business idea. They really wanted to be in that. They just felt that they couldn't be without violating our soon-to-be patents because we had patent pending status. We actually showed them our patent applications, our great claims and patent applications. But here's the goof with patent apps is you file a patent application with claims that are this broad. I want my hands to go more broadly, but I can't go outside of the screen, but you get the idea. But after prosecution, they might be this broad and they might have much less value, but you never know. You don't know when you're looking at patent applications. And their idea was, we want to be in this. We don't want to get mired in litigation. We're going to fund somebody, so let's fund you. So they ended up funding us, and then the .com crash occurred. Thankfully, we got the money before it crashed. But the punchline to the story is that of all those patent applications that we filed, only 1 issued as a patent. 6 were finally rejected. 1 issued, and it's very narrow, right? So if we had gone to them with 1 very narrow patent and 6 rejected patent applications, they wouldn't have invested with us. But because we brought patent applications and they didn't know what was going to occur, our patent applications won the day and we were able to get the investment. So that's one of the great values of patent applications, which is why there's, private investors, private equity investors, there's venture capitalists that are always asking companies to talk about their intellectual property story, and they want to see their patent applications. Now hopefully other companies will be more savvy and ask to see the prosecution history and see how far along they are, and then do some searching and figure out whether you're actually going to be able to get any of those issued as patents. But certainly everybody is looking to see what you have filed before they invest money.
That's very interesting. And that's a really crazy story. In 90 days after that second meeting, you said?
We got a check
90 days
$7
later,
million.
a $7 million investment. See, they thought, oh, he's just a lawyer. But what they didn't know was, oh, he's a patent lawyer.
Exactly.
Because
Exactly.
the other thing there that struck me too, and this is kind of a side note, is that you had that meeting one week, and then the next week you filed 7 patent applications.
Oh yeah, we were
That's
working
no
day and night.
small feat. Yeah, you must have been working 24 hours a day for a week.
Yeah, well, luckily, like you said, I'm a patent lawyer,
Right.
and my partner, while not a patent lawyer, was a savvy, inventive guy who was really helping out with drafting disclosures. But yeah, it was a week. So punchline to the story, I guess the moral to the story is patent applications matter.
Right.
Yeah.
Yeah, that's huge. And did you mention that it was 3 years that it takes for a patent to go through the review process?
Yeah, it's usually in the U.S. The typically it's like 3 years or so before you can finally be granted or finally be rejected, and it's mostly because during that time period there's a lot of back and forth with the patent office, and everything takes time. Just to get your initial response from the patent office could be, 6 months to a year.
And explain again how it works to get the patent pending status. Like, are there certain qualifying criteria that your application has to meet or your invention has
Yeah,
to meet?
yeah, you just file your patent application with the patent office of the jurisdiction that you live in, USPTO, the Chinese patent office, the Canadian patent office. You file, and once you have your filing date, you are patent pending. And in the US, like I say, you need to be that before you can put patent pending on your products.
How do they prevent people from putting in patent applications for things that are obviously not patentable then, though?
Well, that's what some people do. They put in patent applications. I mean, if they're terribly not patentable, that's one thing. You have to have the patent lawyer has to have a good faith belief that they can get a patent application successfully through the system. But there's companies that, even if it's close and they get prior art that looks like it's going to be potentially damaging, they'll file anyway. And in fact, a lot of companies, they don't even do a search. They'll just file and let the patent office do their search, but then they could stamp it patent pending, because sometimes their attitude is this technology is only going to be good for like 18 months. Even if I get a patent, I'll probably abandon it before that, but they have patent pending status.
Right.
Yeah.
Right. Now, this is might be a really obvious answer to this question, but every patent application has to have a patent lawyer's signature on it?
No, you can file yourself. I mean, in fact, the USPTO, and now I'm just thinking about the USPTO. I don't know how helpful other patent offices around the world are, but I'm guessing that, in most countries, they're just as helpful. But there's actually a branch of the USPTO that helps independent inventors get through the patent prosecution system. And then there's books out there too for, inventors that want to file their own patent applications. Now, I wouldn't recommend it because, writing a patent application is a bit of an art. You are crafting. I mean, think about it, a claim. Every word in that patent claim matters. And by the way, if a patent is unsuccessful, and 95% probably are, right? And when I say unsuccessful, you don't make as much out of them as you've spent to get them. But if it's a failure, no one cares. You can file it yourself, right? It's like almost anything in business. If you're a failure, nobody wants to copy you. Nobody's going to sue you because no one cares. So if you have a patent application that you filed yourself and it's not great, your claims aren't as broad as they could have been, and you're a failure in the marketplace, who cares? But what if you're a smashing success in the marketplace, but you didn't draft your claims broadly enough to protect the product that you're in the marketplace with? Now you're going to be suffering. It reminds me of people who write their own wills. Oh, I'm going to write my own will. And then you're dead. And then the will's all screwed up. And stuff that you wanted to give to somebody doesn't go to that person because you haven't done the right things. So it's like whenever you try to take legal, imagine this. You are a plumber. You spend all your time doing plumbing. You're probably a pretty good plumber. And if you do it right, it goes smoothly and you don't have leaks everywhere.
Right.
It's kind of like that with any industry. But when you talk about patents, because they're so costly, it's so expensive to get them and so time consuming, to me, why would you ever try to do it yourself?
It's not worth it.
No, you're going to screw it up. You are, unless you're brilliant and you basically know enough to become a patent lawyer. Even young patent lawyers aren't good at it. Imagine that. Patent lawyers and patent agents have taken the patent bar. They have a science degree. When I first graduated law school and then I took the patent bar, I drafted a claim on the patent bar just so I could pass the patent bar, but I wasn't any good at it. So sorry about that. I'm a patent lawyer. I'm a registered patent lawyer, and I'm still not good at drafting claims way back then, right?
Sure.
So now imagine you're not a patent lawyer, and
you're not even a lawyer.
You're not even a lawyer, you're going to draft your own claims. It's an art, it took me years to figure out how to get good at it. And when I look at some early stuff that I did versus, later in my career, it's a massive difference. So to me, I'd find a patent lawyer to draft your claims for you. The way you can save money, though, let me say this. The way you could save money is to have a very thorough disclosure, like have everything that the patent lawyer needs, because it's all about time, right? Abe Lincoln made a comment, which was a lawyer's time is his stock, and actually his or her stock in trade. If Abraham Lincoln were around today, because I'm not sure there were any female lawyers in the 1850s and 60s, but think about that. Your time is your stock in trade. So if you only have one thing to sell, which is your time, well, if the inventor can save me time, it will cost the inventor less. So I wouldn't recommend drafting a patent application and filing it, but I would recommend thoroughly drafting your specification and getting all the information that the patent lawyer needs to then draft the patent claims and file your patent application.
Yeah, it's really interesting how this whole process works, and just how both expensive it is, but also how beneficial that it can be to your business. But yeah, so let's move on to Space Force versus Star Trek. I'm excited to talk about this one because I love science fiction, and I love outer space. And
what about Star Trek? Do you love Star Trek?
I never.
You're not a Trekkie.
Star Trek was the only, pop culture sci-fi series or movies that I just never got into. But I respect it. I do.
Okay, so I am a bit of a Trekkie. I mean, I'm not a fanatical Trekkie, but I've watched every episode of the original Star Trek with James T. Kirk.
Never would have guessed.
Yeah. Star Trek Next Generation with Jean-Luc Picard. One of my favorite shows of all time was Enterprise, which was the 2000 version, which in the timeline it predates James T. Kirk, and it has Jonathan Archer, like maybe the greatest character in any show ever made is Jonathan Archer of Enterprise. But, I've watched Voyager, I've watched the movie. So yes, I love Star Trek. But so this, it's funny that every time we do a case in the news, it's always about like trademarks and stuff, even though patents are like the most popular form of IP, but in the news, trademarks get all the buzz, right?
Right.
So in this case, what's happening is, and maybe when you edit this and put it up, you can put the actual logos on.
Yeah. I'll have them up on the screen here.
Cool. Because so Donald Trump and his gang come up with, and when I say gang, I mean his administration. I'm not trying to be derogatory about Donald Trump because I'm not. I'm not. But anyway, Donald Trump and his administration came up with the Space Force, which is pretty cool. So they needed a logo for it. So when you look at the logo for Space Force and you look at the logo for Starfleet Command, they look almost identical. I mean, there's no doubt that somebody in that administration is a Trekkie because they have a logo that is a knockoff of
Starfleet. By the time we publish it, it's going to be on screen right now. And so you guys can judge for yourself.
Yeah, exactly. It's really pretty cool. So anyway, I mean, if you're going to take a logo to create the Space Force, take Starfleet Command, right?
Right.
So anyway, and they did. So anyway, so I saw this thing about, I think it was George Takei. What's the name of the guy who played not Han Solo? Zulu. George Takei, I think his name is. But anyway, or one of those guys, they said it was trademark infringement. And And of course, I immediately started thinking, trademark infringement. Could it be trademark infringement? So the question is, when you're looking at these two logos, and Ray, hopefully you have them on the screen now.
Yeah.
Is it trademark infringement? So I go through in my head, what are the basic things? Well, first of all, are they confusingly similar? And they clearly are confusingly similar. Are they in the same industry? And the Starfleet Command is kind of like a Space Force, right? They provide Space Force services, and the Space Force is a Space Force services, right? So they're in the identical industries, right? They're both protecting somebody with Space Force. And so you'd think, wow, this could be trademark infringement. But then there's one fundamental problem, and that is you need to remember, trademarks only exist in connection with products and services that are being used in commerce, right?
Right.
It's hard to imagine how you can spin a fictional service like
Right.
Starfleet Command as being used in commerce. I can't buy that service. I can't go to what's his name? Who's James T. Kirk? I can't pull it. But anyway, we're gonna pull it.
The Priceline guy now.
Yeah, exactly. William Shatner.
William Shatner. Thank you.
I can't go and get William Shatner to provide me a Space Force service with that logo. So there is no real service. It's artificial. It's not being used in commerce in connection with Space Force services.
Right.
So there's no trademark infringement. However, there may be copyright infringement because, and I'm not a copyright expert, but I know you can copyright fictional characters, right? You could copyright Mickey Mouse. Well, Walt Disney did copyright Mickey Mouse and Superman and Spider-Man and Batman. So why couldn't you copyright? That logo is owned by somebody as a copyright. The artificial Starfleet Command. So that could be a problem. But when we talked about it a few minutes before we started, I did a quick search to see about other fictional characters, and there's a great example. There was this company called Fortress Grand, and they have a product that's in the marketplace called Clean Slate. And Clean Slate essentially wipes emails out, right? It's like a wiping software. So there's also a movie called Dark Knight Rises. And Dark Knight Rises, I think, is by Warner Brothers. So Dark Knight Rises, is it Dark Knight Rises? I think it's, let me just see here.
Yeah. It's one of the
Dark Knight Rises. So Dark Knight Rises has a character, Catwoman, very attractive. But Catwoman has a criminal history. And Catwoman wants to wipe her criminal history clean from every database in the universe so that she can start a fresh life, I guess. Now, by the way, confession, I never saw Dark Knight Rises. So I'm just going by what the article said. But anyway, so Catwoman has to, get this software from the Rican Data Corporation. And it's called Clean Slate. So Clean Slate clean slates you. It wipes all the, information about your criminal history from all the databases on the planet. So Fortress Grand sues Warner Brothers for trademark infringement because they're using the term clean slate, and they're worried that it's confusingly similar to the clean slate that they actually have in the marketplace.
Right.
But again, the problem is you have to actually be using a product or service in the marketplace to be committing trademark infringement. So the court actually said, basically, I forgot the exact language in the thing, but it said, what kind of bumpkins would think that is a product that the Warner Brothers has licensed it and now they're selling it. It's just on the TV show. It's on the movie. There is no real Rican Data Corporation, and they're not selling a real slate cleaner that can help villains like Catwoman. I guess she's kind of like a quasi-villain, right? To get a clean slate. So they held, I think it was the Seventh Federal Court Circuit this went to, and they held that there was no trademark infringement.
Wow.
So that's our case in the news.
Interesting. Yeah, and in that case, then it couldn't really be copyright infringement either.
Well, because the real Fortress Grand is using it as a trademark.
Right.
So the question is, do they have any, or they're just using the word clean slate as a trademark. So they don't have it's not like they have a logo like that cool logo from the Starfleet Command. Now, but what if they had a logo? What if they had a cool logo?
Warner Brothers used the logo.
Maybe that's a copyright infringement case. Good point, Ray.
Could be.
All right.
Yeah, the only way that that the Space Force could have ripped off Star Trek more than it already did is if they called it the Starfleet Enterprise or whatever. Starfleet Command. Yeah.
That's right. When you look at
those Space Force, it's Starfleet, and then it would just be like.
Right. Well, I saw this thing on the news, which has, or not on the news. I just did a quick search on it, and it showed the two logos side by side. Then it showed Jean-Luc Picard side by side with Donald Trump.
Okay, now we got to stop before we get political because now
we're
upsetting half of our audience, right?
You don't want to compare a fictional leader with a real leader, and what are the flaws and positives of each?
Right.
You don't want to be doing that.
Yeah, no, we'll skip that maybe next episode. We'll leave you on a cliffhanger.
Or a different show altogether.
Oh, yeah, different show altogether.
With perhaps different people in it.
Yeah. Other than you and me, right?
Exactly.
All right. Well, thanks, guys. Thanks so much for sticking it with us here through our conversation about patent pending status, the Space Force, and Star Trek. If you liked what you saw and heard, please click the like button, subscribe, and tell people about our podcast, Stuff You Should Know About IP.
See ya.
See ya.